the developer decides not to do it, then what happens is the owners or the purchasers will have to then come together, figure out a way. There are developers who don't want to hand over a project to the Apartment Owners Association. Associations have not been formed for even 8 to 10 years after the handover has happened.
Hi everyone, welcome back to the next episode of our Connect with Experts initiative. I'm Ashish Acharya, I'm the founder of Propsoch.com, India's first expert-based home buying platform, where we are trying to bring back the joy in home buying and our experts do all the heavy lifting at the back end for you. So today we have a very special guest with us, Mr. Gerald Manoharan, whom we fondly call Jerry also. He's a very close friend of mine. We've been working for years together. He's a partner at JSA and he's a specializer in corporate law. But I would leave it to him to really introduce himself and what he does and what's his specialization, and we can take it up from there. Welcome to the show, Jerry.
Thanks, Ashish. Thanks for having me here. I'm really happy to be doing this kind of a knowledge sharing kind of a session with you, so that your audience obviously learn and benefit some bits of it. I am primarily a corporate commercial lawyer, so I've been doing corporate commercial law for over 20 years now. I have a specialized team which also focuses on real estate. So as part of our real estate work, we do land title review, documentation for development, sale, leasing, you name it, the entire spectrum.
Well, that's fantastic, Jerry. And I've worked with you in real estate in my previous roles, and I know how great you are, how professional you are in your approach. So I really look forward to leveraging your expertise to help home buyers actually make the right decisions as they go about buying homes in India, right? So today, Gerard will specifically focus on a very important topic, which is the with respect to the whole Apartment Owners Association and the RWA, right? Today we'll basically talk about the Residents Welfare Association and what are the different nuances which go into forming one. Who are the stakeholders, what is the process, and what is the benefits, and what the home buyers really need to keep an eye out for as they go about this complex process, right? So if you could shed some light on what is the difference between Apartment Owners Association and Resident Welfare Association? Are they the same with different names, or is there something really legal about it?
No, so I think people sometimes interchangeably use this phrase. But Apartment Ownership Association largely derives its significance and character from the Apartment Ownership Act. Okay, so the Karnataka Apartment Ownership Act, it's a 1972 legislation, right, is what provides for the formation of a owners association of an apartment. Whereas a resident welfare association is like any other socio-cultural, support group which can be set up by any person in any locality. And their purpose is also to obviously ensure the mutual benefits for each of the residents in that particular area. But the distinction is that the Apartment Ownership Act facilitates the creation of a specific association so that it provides legalities to the structure of this particular association, because it has some very specific roles to achieve within the provisions of the legislation.
Right. Fantastic. And what's the process that home buyers need to follow when they're taking, control of the project from the developer on completion? How do people go about it?
See, that's an interesting question, and also, the process. It's kind of a process-driven kind of thing, because what happens is typically the developer identifies a piece of land, gets the approvals, and then registers the property on RERA if it is to be registered, and then he starts selling out the units to the various purchasers. Okay. Now, what these purchasers do is they acquire certain interest in each of the units. So basically they get a title, they get a heritable kind of interest in an immovable property, which is identified by their undivided interest in the land. Okay, a certain interest in the common area of the development, and of course the square footage of the apartment itself. So all of these really constitute the ownership of that particular purchaser. Okay. Right. Now, usually what happens is that once the developer has sold all the units, okay, and he has managed to, and then what happens is he's executed sale deeds to all the owners or the purchasers of the apartment. And then, he also procures an occupancy certificate, right? Depending on, the type of the project, he goes and obtains an occupancy certificate, which also gives him other licenses in terms of power, pollution control and the other licenses. And then he undertakes one very interesting step after that. It's a bifurcation of the khata. So the bifurcation of the khata, or the possession certificate, as you mean to say, is a document whereby The larger land parcel may have had one khata, and that gets split into the number of units or apartments which are sold. After this exercise is done, you are able to identify the apartment with an apartment number. Each apartment has got a clearly identifiable square footage in terms of area, common area, interest, UDS. The third point is that certain apartments could have exclusive areas. For example, some may have a garden, some may have an additional balcony or whatever, right? So there are exclusive areas which are provided. You're able to identify that. And the fourth point is that you are able to identify each apartment with a specific referenced number, which is issued by the municipal corporation or the corporation as the case may be. Now, the developer, because he has all of this information, he proceeds along with the cooperation of the owners to submit this apartment. So basically, a deed of declaration is signed up by the developer / the owners, submitting this development or this whole apartment complex under the provisions of the Karnataka Apartment Ownership Act. Okay, so this can happen two ways. One is the apartment owner, at the time of executing an agreement to sell or a sale deed, gets a power of attorney from the purchaser, telling the purchaser that he will sign on their behalf to set up the apartment ownership association. Or if the developer decides not to do it, then what happens is the owners or the purchasers will have to then come together, figure out a way, and then get all the signatures of the various apartment owners, and along with the developer of the property, submit the deed of declaration to the sub-registrar for registration. So this is typically how it happens. Now, as a follow-on, right, what is a better approach? Is the best? This is the next question you probably will ask me. And what happens is, I have seen it working, in both scenarios. Okay. Now, when the apartments are sold to all the purchasers, okay, then, and if the developer does not have a power of attorney from the owners, okay, to actually, present the deed of declaration on the behalf of the purchasers, then we are required to get the signatures of every apartment owner, okay, on the deed of declaration. Plus, you may need the signatures of these apartment owners at the time when they are presented before the sub-registrar, which sometimes may entail that you will have 200 people standing before the sub-registrar's office, for the registration. Now, that is going to be a mayhem and practically impossible to achieve. But we have a problem here, because there is a very high possibility that not all the owners are localized. There is a very high possibility that not all the owners are going to be in India. So then what happens is you are adding another level of complexity to the problem, because you will then need to get power of attorneys from those people who are overseas. Once the power of attorney comes into India, you need to get that adjudicated and stamped. Then you get power of attorneys from other people. Okay, so typically what happens is, where the developer does not have a power of attorney in his name, so a few people in the association come together, the primary movers, as you may call them. They come together and they probably get the power of attorneys executed in their name. So they collectively, on behalf of all the residents, then go and submit the document for registration. So according to me, an easier process is for the developer to get a power of attorney, because he gets it very easily at the same time when the purchaser is before him at the time of executing the sale deed or an agreement to sell. But if it were to be pushed to the subsequent stage, then there is a lot of paperwork, there is a lot of procedure to be followed, which is extremely time consuming, because some of our developments are really large with 700, 800 or even 1,000 apartments. So getting something like that organized is not an easy task, and it's also very expensive.
Right. And we always hear about a lot of conflict where the developers, pushing the apartment owners to form the association and take over possession, but the homeowners are actually pushing back, saying, the work is not really completed on the project. So can you shed some light on this aspect of it, and what are the pros and cons of actually taking over the whole project as an association?
See, here again, I have seen both worlds, right? In some situations, there are developers who don't want to hand over a project to the apartment owners association, because obviously, they are enjoying the maintenance charges which are being paid by the apartment owners. There is no structure. There is no body which is there to question them. They can do whatever they want to do. So there are instances in Bangalore where apartment ownership associations have not been formed for even 8 to 10 years after the handover has happened. Okay.
Wow.
So yeah, and then interestingly, what happens is, in some cases, yes, the developer wants to hand over the project in scoop, right? We don't know why we have those kind of instances, But maybe, the developer is having a lot of heat from the customers and from the purchasers, and therefore he feels that there is no reason why he should continue with this particular project. But also what tends to happen is, let us assume if the developer has not been very transparent with the purchasers in the manner of utilization of the sinking fund or the advanced maintenance fund, and he's probably already used it up or he's misappropriated it for any other reason. He wants to get his hands off the dirt as soon as possible. And he wants to leave the crying baby with the apartment owners so that they can deal with it themselves. So that issue is also there. Okay. But one of the main reasons why I think some apartment owners want to hand over the project is because of just, they don't have the capability of handling the snags issue anymore. So every apartment, whenever it is handed over, there are plenty of snags, right? And today what you're seeing is a lot of apartments are being developed in a phased manner, right? So are you going to have an apartment ownership for each phase, or are you going to be doing it on a collective basis? So what is the strategy, right? So there again, this play of time comes into picture. Sometimes the developer will never allow the apartment ownership to be created so long as he's able to clearly establish, that all the phases have been fully developed. Now that becomes a big problem.
Right. Yeah. Now, this is a very important point you've raised, because now with the integrated townships coming up, where you have a mixed use of residential, commercial, retail, schools, everything, right? There are two aspects to it. One is how do you really create? Do you have a federal association for the entire township? How do you share the maintenance cost between all these different kinds of projects? And within a residential project, if there are multiple phases, how do you really figure out how many associations you want to create? Is there a governing body for all the associations? What are the rights of each of these associations, right? And more importantly, how is the cost of common area maintenance split between all these associations?
So let me discuss it in an ideal scenario, right? So you have, let us assume, a large development which has multiple forms of residential development. I'm not including the commercial, the retail, because those obviously will be excluded from the scope of this for the purpose of the creation of the apartment ownership, association. Now, let us assume that there is a development which has a condominium, which is high-rise towers, okay, and within the same place they also have multiple clubhouses, okay, and then they have villas, okay. And when I'm referring to villas, I'm not referring to row houses, okay. I'm not referring to. I'm talking about exclusive villa plots where the plots have been defined by way of a schedule, okay. Now, this is an ideal setup. So typically what happens is, it also applies and implies that the FSI for the apartment construction has been leveraged separately and independently of the leverage of the, of the extent of the area which has been earmarked for the development of the villa plots, or the layout, as you may call it. These are two separate things. Common, in some cases, what we've also seen is even the amenities and the facilities are completely separate, because the nature of the amenities also are very different, right? The condominiums or the high rises require different forms of infrastructure as opposed to the villa. So in that situation, what we've really seen is that the apartment owners usually set up the apartment ownership association, owners association, under the Karnataka Apartment Ownership Act. And since the villa, so technically, privately owned plot owners, right, don't fall within the definition of a building under the Karnataka Apartment Ownership Act. So what they usually do is set up a association, either they just set up an association as a body of individuals, like an association of persons, or AOP as you may call them. Some of them, try and have loose trust structures, which again, I'm not getting into the legality of it, but they try and do trust structures. Some even, go ahead and, try and construct more formal structures like a society, right? Now you have the association, the apartment owners association on one hand, and you have the society of the layout or the plot owners, and they have typically, usually what we've seen is they have an umbrella agreement, right, where they decide on the appropriation of cost and expenses depending on the extent of common infrastructure that they may share. Now this is the very ideal situation. There are some of the older layouts, I think have been planned this way. But what we are, but the newer trend is obviously is something which we'll need to work around. Okay, so what you're seeing today is that developers earmark a large extent of land on which they develop high-rise residential apartments, and they also provide villa settlements, right? They also set up large villa settlements on an undivided share basis. So, which means that those villas are the layout. So those villas don't have absolute ownership with respect to the land on which they are standing on, but there is an undivided share they hold with respect to the overall development.
Absolutely.
This implies that the developer has leveraged the FSI of the entire development. Okay.
Yes.
So typically, what happens in this situation is that the person who so-called owns a villa is technically holding an apartment, but that apartment is standing on the floor for all practical reasons. But otherwise, it is pretty much covered under the same kind of legal rights which an apartment owner has in terms of his right being limited to an undivided right in the land. Okay.
Right.
Now, because the FSI may be fully leveraged on a development, the unfortunate part is that the villa owner will never be able to make any additions on this property.
Right.
Of course, this is also limited. The sale deed, when executed with the villa owners, will clearly stipulate that they cannot even lay an additional brick on the wall. So the question of having to do any modification does not arise at all.
Sure.
So in this situation, what happens, Ashish, is there is a kind of a confusion as to while and these two guys are very exclusive, right? So the apartment owners, maybe they don't want to deal with the villa owners because the villa owners' rights, obligations, their problems are different from the apartment owners. So they want to maintain two different associations as much as possible. But the problem is this, right? So maybe the apartment owners can still go ahead and set up the Apartment Ownership Act, set up the association and the deed of declaration under the Apartment Ownership Act.
Yeah.
But when they are submitting the deed of declaration, the funny part is, how do you identify the footprint of the building?
Yeah.
Because you're now talking about the entire land area, which may run into 100 acres or whatever. How do you identify the footprint of this particular apartment vis-a-vis the overall property, and as against the villa owners and the rights of the villa owners? So that becomes a challenge, but that is something which you may have to deal with. And as regards the villa owners, they are now confused because had they been a standalone villa without any, this whole idea of having undivided share, then probably they would be treated as a layout. And therefore, they could have comfortably registered under as a society or as a trust or whatever they decided to do. Right. But now they are neither an apartment nor are they a full-fledged and exclusive villa. So therefore, do they register themselves under the Apartment Ownership Act? So that's the question, because there are some legal experts who clearly say that villas cannot register under the Karnataka Apartment Ownership Act, right?
Okay.
So that is a view that some people take, and that debate is on.
A follow-up question on this, Jerry. So if once the apartment association has taken over the project from the developer, right? What is the liability of the developer going forward with respect to that project? Is he free of any liabilities, or is there any other act which is covering the home buyers with respect to the developer's obligations?
Yeah, so the RERA says that the developer is liable for 5 years, after the handover of the project. So in most instances, what we have seen is that developers usually entrench for at least 3, 4, or 5 years in a project, and it's only then after that they hand over the project to the owners, because very often there is unsold inventory, so the developer continues to stay on. But a response to your query is, yes, he is liable for 5 years.
Understood. And Jerry, how does redevelopment actually fit in all these things? Redevelopment, of course, is 30, 40, 50 years into the future, but a lot of redevelopment is already happening in a city like Bombay, right? And it will definitely catch up in other cities. So what should people keep in mind with respect to redevelopment as they go about forming their association?
So redevelopment plays a very important part, and it is reality. I mean, you will have to bring in the new at some point of time. Yeah. So therefore, the document, which is the deed of declaration, plays a very important role. Especially in in a multi-utilized kind of large area where there are different types of development. And as I mentioned to you earlier, you have different types of developments, and you may have probably multiple associations within the same development, right? Mm-hmm. So let us assume that there is one association which wants to bring down its building. They have consensus with all the owners, right? Maybe they're getting a better FSI now because the laws have changed. Maybe 30 years later, the FSI ratios could be phenomenally higher. They want to leverage on that, and the owners come together. But what you also need to realize is that there is always going to be shared infrastructure, right? Because it's a larger development, right? This problem on a standalone development, I don't see this being a problem. But in a larger development like the ones you see, the newer developments in Bangalore, there'll be a lot of shared infrastructure. The issue of the footprint of the existing and the current building will have to be taken into account. Because very often what tends to happen is that the basements are shared basements across different buildings, which may have different associations.
Right.
Okay. So identifying the actual extent of the footprint. But what we have also seen of late, and an easier recourse to that is that the master plan or the developmental plan, which the developer gets an approval of, right in the initial stage,
Right.
you use that as the reference document going forward. So in that master document, if you are able to demarcate the land or the footprint of the land very well, and you also have clear provisions in terms of the basement or any shared infrastructure, I think that will give you a lot of clarity at the time of redevelopment of a project. Okay.
Right.
But redevelopment itself is very interesting because all the apartment owners will need to come together, okay, and sign up for a redevelopment, right? So very often, even in Bombay, as you rightly mentioned, a lot of redevelopment projects are stuck because of litigations. Because more than litigations, I think what is interesting is there are a lot of testamentary issues. Succession-related issues.
Right.
Because the person who bought it first, passed on, and the property is really not devolved properly, and the subsequent guys will need to go through a whole motion of probate and all of that, right? Depending, especially in Bombay, you have that issue. So
Right.
that takes time, and because of which the development process gets delayed.
Sure.
So that is something which needs to be kept in mind if you're looking at redeveloping a project. Yeah.
No, absolutely. I think that's very, very useful. What's your view on some of the developers actually not really handing over the entirety of the land parcel to the association? There have been instances where certain common areas, clubhouses, roads have been kept in the position of the developer, and the rest of the lands have been handed over to the association. What's your view on that?
See, there is no law which really prevents this practice, right? Now, something like this we have seen again in developments where the developer has additional phases to develop, right? He knows that the common road is going to be used for access to that future development. He has not even probably tied up that land parcel, but he is in a far off negotiation in getting that land parcel, which is probably adjacent to this particular development. So he ties in these kind of issues. So that is the first thing which we have seen with roads. The second thing which we've also seen is with respect to clubhouses, right? Many developers retain a portion of the clubhouse or hold an interest in the clubhouse.
Sure.
Now, this is very interesting because in my mind, when I buy an apartment in a development, I have paid for the undivided share in the land, the carpet area of the apartment, right? Or
Right.
you can call it the carpet area or the built-up area, okay?
Right.
And the third component I pay for is a proportional extent in terms of the common area. Now, the clubhouse usually falls within the definition of a common area, and I have perhaps paid for it. Now, in all the owners have paid proportionally for the club area or for the clubhouse,
Right.
how is it that the developer is still able to retain certain interest in the clubhouse? So that is something which needs to be evaluated.
Right.
And this is why, purchasers should clearly ask for the Excel sheet, okay, which sets out the complete area statement of the development. That
Got it.
becomes very important because otherwise you will have absolutely no idea how the developer has loaded the common area factor, to the built-up area, okay, and you will not understand whether any extents have been retained. Now,
Sure.
even if the certain portion of the club were to be retained by the developer, I think the developer has to have certain title or legal rights with respect to that portion of the land.
Right.
So how they achieved it or how have they achieved it is something which needs to be verified.
Well, I've heard the counter argument that because the developer maintains the clubhouse, the quality and the service levels in the clubhouse will be maintained to a certain standard. Whereas if you left it to the residents to manage it over a period of time, because of cost cutting, because it's not being run as it doesn't have a P&L on it, right? Like how a developer would look at it. So there could be a chance that the clubhouse would deteriorate in terms of quality and service. So I guess there are pros and cons to both the approaches, and end of the day, the residents will have to kind of take a pragmatic view, because they've already bought the house, and there's only so much that they can do with respect to such issues, right, which are out of their control. But Jerry, tell me, how much of legal assistance is out there for home buyers and associations? Is there a way that associations formally engage with law firms, or is it all being done on an ad hoc basis, without any real formal legal understanding of the whole thing?
No, I think purchasers today, especially of the larger developments, are better informed, right? And usually, we see a lot of residents waking up to a reality of their inability to manage their own affairs when they realize that the developer is not letting go of the maintenance and management of the entire development. That is when they say, why is this happening? Why are we formed the association? Then they, get the task, rolling. So, and of course, what we've kind of seen is that people are reaching out to lawyers who have experience in this space, or sometimes to law firms. We've been advising, a few, or associations or individuals who come to us to set up their associations. So I think largely now the awareness is better.
Okay, that's good to know. I think given the recent Bangalore floods where a lot of premium properties were flooded, I think the associations were actually seeking legal counsel to kind of help them figure this out with the developer and the authorities, right? Because
Yes.
a lot of them had inbuilt violations. A lot of them had challenges in the land itself which were not captured earlier. So
I think what tends to happen is that when any development is happening, right? So the purchasers obviously has never been to the land prior to its development. Okay, sometimes existing structures are demolished and they are developed again. But the problem is, in terms of compliance with the development plans and the approvals, and even so, basically understanding the contour of the land, right? So earlier days, people would go physically, inspect the land, see how the land was placed. They'll know if there was a tree on that land, or they'll know whether there was a canal that was running beside the land, or they will know all of this information. But today, the purchaser is very distant from the reality of the ground. And the only reality that they see is what is shown on the web page of the developer, or in these glossy promotion documents and brochures. Right. So therefore it's a flat land. It looks beautiful. I mean, it's like meadows and rolling greens, so let's acquire it. But for all there could have been a stormwater drain there, there could have been a lake there, there could have been a pond there. So and sometime you will float, obviously.
Yeah. I guess the meadows are because of the access to water bodies in the vicinity.
That's true.
So that's great, Jerry. I think this was very, very insightful. I think both for me and for viewers of the video. Would you be able to tell us what are the top 2 or 3 things that home buyers need to keep in mind as they go about buying their dream home? From a legal perspective.
Yeah. So the first thing, is that many home buyers rely on the diligence or a title approval of their financial institutions. They do not engage an independent lawyer to review the documents for them. Please don't do that, because an institutional investor who approves a project reviews the project, the title, from a very different perspective. You as an individual buyer, your interests are very different. It's your hard-earned money. Right. And you want to make sure that you have tested the credibility of the developer. You made note of the successes that he's had. You've done some diligence to make sure that he's not going to be a defaulter, that he's not going to delay the project. You're going to do some diligence to understand that all his projects have been executed largely on time, that he's not cheated people. There are no court cases pending against him. There are no consumer matters pending against him. He's not received negative press. So all of this, you will have to verify using a credible agency. Because if you do not do that, then caveat emptor. You will be responsible for your own actions. Right? So please bear that in mind. First important point, get proper advice before you buy your property. Okay. The second important point is you have to ensure that the documentation that is provided to you, you read the documentation. Very often, highly educated people don't read the document. I'll give you an instance. I was talking to somebody recently who was sitting on a villa property in a development. All through, this person believed that he had exclusive rights to the plot and could therefore do some additional constructions. We then later pointed out to him that unfortunately he had only exclusive rights to use the plot, and unfortunately the FSI was leveraged and he would not be able to place an additional brick. He probably had not read the document, or he read the document and understood the facts differently. So you need somebody to review the document and help and explain to you what the document really means, because sometimes legal language can be complicated and it can defy common sense.
Yes, that's so true.
Yeah. And the third important point is take your time, and that's about it. I think these two are very, very important. The third part is, because we are contextual and we're talking about Apartment Ownership, Act and the formation of the association. Make sure that the developer is able to put it in place for all the owners, because if the developer does not do it, trust me, for the owners to get it off the ground is going to take a long time, because people just don't agree to things. and then getting the document in place. And a bylaw is not a small document. Bylaws could be a 30-page or a 40-page document. So I've had some crazy situations where we've been trying to do bylaws with residents, because there will be one bunch of residents who will want to have special clauses about the care of dogs. There will be one bunch of people who want to have special clauses about the care of cats. Then it's a mess.
Right.
So make sure you have a simple document, a workable document, and then if you want to change it, you change it by majority vote as provided in the bylaws.
Oh, that's fantastic. I think that's been super insightful, Jerry. Thanks for your time. Really appreciate it. And look forward to more sessions like this with you.
You're welcome. Thank you so much.
Thank you. Take care.